Good afternoon to you. Today we will continue with the Constitution. Of course, a different topic. Uh, this is the economic weaker section reservation. It's a very important topic. Important from the point of prelim, final, and interview. Kindly follow closely. If there is any doubt, you may kindly indicate in the comment section. I shall be grateful. Recently, you may have seen a news report that the Supreme Court has referred to the Constitution bench the public interest litigation and other petitions which challenged the constitutionality or otherwise of 103rd Constitutional Amendment Act 2019 providing 10% reservation for economically weaker sections of society in government jobs as well as for admission to government-run educational institutions and private educational institutions other than the minority educational institution covered under Article 30. This is the 103rd Constitutional Amendment Act. This has been challenged in the Supreme Court and this has now been referred to Constitution bench consisting of 5 judges. I have already told you Constitution bench is to consist of 5 judges. That is why we have the quorum for a Supreme Court is 5. Now, in this connection, you should also know that as per Civil Service Exam 2019 results, which was out recently, out of 829 candidates selected, 78 are from economically weaker sections and 251 belong to OBC. 9 economically weaker section candidates and 71 OBC candidates have been kept on reserve. Out of 180 selected for administrative service, 18 are from economically weaker sections and 52 are from OBCs. Similarly, out of 150 IPS candidates, Indian Police Service candidates, 15 are from economically weaker sections and 42 are from OBCs. So, work hard, try to avail the benefit of economically weaker section society, that is 103rd Amendment Act 2019. Since the Supreme Court has not granted any stay has not been given, remember, even though it was challenged in the Supreme Court, so many petitions have been filed against the amendment. But Supreme Court has not granted stay. Since it has not granted stay, the chances of your success in the ensuing 2 years seem to be bright, because now they have to constitute the bench and the bench will hear the government's view and the petitioner's view, which will definitely take more than a year or so. So it is time for you to struggle hard and get through, seize the opportunity and get whatever concession is possible from the constitutional amendment. This is the first point I want to submit to you. Secondly, when we were dealing Article 15 and 16 in fundamental rights, we have dealt with the amendment in detail. So, again to go through the amendment is infructuous. Nevertheless, in view of the importance of the issue and also the possibility of questions being asked on the topic, both in prelim, final, and in interview, is more, I like to discuss this issue again only from examination point of view. Only from examination point of view, no academic. Firstly, let us see the amendment which came into force from 19th January 2019. When it came to force? 19th January 2019. The Act amended 2 articles. What are the articles? Article 15 and Article 16. Both the articles fall under right to equality. Both the articles fall under right to equality. Right to equality is different. Equality before law and equal protection of law is different. Right to equality is the fundamental right. That is 14, 15, 16, 17 and 18. All put together we call right to equality. Whereas equality before law and equal protection of law is in Article 14. So, right to equality covers Article 14, 15, 16, 17 and 18. Where? Under Part 3 of the Constitution. Otherwise called fundamental right. These are all PT questions. Remember, the Act amended 2 articles, 15 and 16. Both fall under right to equality, which covers 14, 15, 16, 17 and 18. In which part? Under Part 3 of the Constitution, otherwise called fundamental rights. So, every word is PT point of view important. Article 15 added a subclause under which the state can make special provision for the advancement of any economically weaker section of citizens, irrespective of Class G of Class 1 of Article 19. What is that? Right to undertake any trade, business, profession in any part of India, as well as Class 2 of Article 29. What is that Article 29? Right of admission in educational institution irrespective of religion, caste, grade, etc. This does not also affect the classes 4 and 5. So, this is Article 15, one subclass. Another subclass added through this amendment says that the state can make a special provision for advancement of any economically weaker section of citizens relating to their admission to education institutions aided or unaided by the state other than minority education institutions covered under Article 30. It has been made clear in this subclass that this reservation would be in addition to the existing reservation and would be subject to a maximum of 10% of the total seats in each category. Again, it is also clarified, as you know, that what is provided in Class 4 and 5 will not be affected. That is, the reservation already given for SC, BC and SC, ST will not be affected. This has been made clear. On the similar analogy, Article 16 has also been amended by adding a clause under which the state can make a special provision for reservation of appointments or posts in favor of economically weaker sections of citizens, in addition to the existing reservation and subject to a maximum of 10% of the posts in each category. This is the amendment for Article 16, and Article 15, two classes have been added, two subclasses have been added, which I have explained. Now, in other words, the amendment extends 10% reservation in direct recruitment in government jobs and also for admission in education institutions, whether it is aided or unaided, except minority education institutions. To whom? To economically weaker section among all castes and communities, Christians, Muslims included, who are not eligible under the existing quota. Remember, Muslims and Christians are also included if they are not included in the existing quota. The 10% quota for economically weaker section is in addition to the existing cap of 50% reservation for SC, ST and OBC, taking the total to 60%. Taking the total to 60%. Now 50 was the original ceiling and this 10% added, so reservation prima facie is 60% now. This will be over and above the 50% ceiling as mandated by the Supreme Court in Indira Sani, that is Mandal case of 92, and Nagaraj case, which has been decided by Supreme Court. Hence the need for constitutional amendment. So this is the background of the constitutional amendment. Now, who comes under economically weaker sections? That we should know. First is number 1, annual household income below 8 lakhs. Number 2, agriculture land below 5 acres. Number 3, residential house below 1000 square feet. Number 4, residential plot below 100 yards in notified municipality. Now, which are the articles of our constitution are relevant to this amendment? Third point. First we have seen who comes under the category of EWS. Now we are seeing by amendment of 103rd constitutional amendment, which articles are affected. Tomorrow if Supreme Court is seeing this, what point, probably it is only presumption, what point the Supreme Court will be looking at, and what would be the argument of the petitioners and what would be the argument of the government. This is, we are just analyzing for information's sake, and it is a matter sub judice. We are only educating ourselves how to deal with this issue. Number 1, Article 12 is involved because it defines the term state. Article 13 read with Article 32, that is judicial review by the Supreme Court and definition of law given in Article 13, and Article 32 because the right to move Supreme Court for enforcement of fundamental right, because Article 32 itself is a fundamental right. So the Supreme Court cannot refuse to entertain, it has to entertain provided it is a writ for enforcement of fundamental right. So Article 12, 13, 32. Then 14, equality clause. Then 15, Article 15 and 16, this is the impugned provisions. Article 19, right to carry on any trade, profession, etc. Article 29, protection of minorities for admission to educational institutions. Article 30, right of the minorities to establish and administer education institutions. Article 46, which is part of directive principle of state policy, in part 4 of the Constitution, in particular promotion of educational and economic interest of the weaker section of the society, including SC/ST, that is Article 46. Article 335, maintenance of administrative efficiency while making reservation in appointments and posts. In addition to these, what others are affected? Doctrine of basic structure, number 1. Doctrine of judicial review, number 2. Doctrine of maintenance of harmonious relations between fundamental rights and directive principles as envisaged in Kesavananda Bharati case and Minerva Mill case by the Supreme Court. Now, up to this we will see now. We will continue in the next class, one by one. Thank you.